Start. Para. Whether the state government has any right to impose a minimum price condition under Section 36A of the Maharashtra Land Revenue Code 1966 (MLRC) when approving acquisition of land by a non-tribal from a tribal is the prime question we have been presented with. When adjudicating this writ petition, we hold in the affirmative. As an alternative, we have been petitioned to declare that the state government must have regard to the value of the land as of the date of the application under Section 36A and not at the time of the approval. The law on this issue is well settled. The value must bear reference to the time of a valid application, complete in all respect. However, in the facts of this case, the value of the land in 2012 has been rendered irrelevant because the petitioner's proposal to acquire tribal land was rejected in 2021. Para. The petitioner, Mr. Naveen Shah and Mr. Nitin Shah, have approached this court under Article 226 of the Constitution of India seeking intervention against the imposition of a minimum price requirement as part of an approval granted by the respondent number 1, the state of Maharashtra, for acquisition of land measuring 42.7 acres bearing survey number 30/6 situated at village Thane. The subject trial land is admittedly owned by respondent number 6 to 10, namely Mrs. Baby Devendra, Mr. Yogendra and Mr. Nisha, who are also admittedly tribals. The additional secretary (revenue) is respondent number 2. The collector is respondent number 3 and the additional collector is respondent number 4, while the divisional commissioner Konkan division is respondent number 5. The state has approved transfer of the subject tribal land from the Paneras to the Shahas, but has imposed a minimum price based on the annual statement of rates published under the Maharashtra Stamp Act 1958 as applicable for the year 2023-24. This has been applied because the approval for transfer under Section 36A was granted in the year 2023. Para. A plain reading of the foregoing would show that tribals are special protectees under Section 36A of the MLRC, which contains a scheme of deep intervention by the legislature to protect the occupancy interest of tribals in land. The salient features of Section 36A may be summarized thus. A. The prior sanction of the state is a requirement of Section 36A (1), regardless of what led to the transfer, sale, gift, exchange, mortgage, lease or otherwise. Notably, even the execution of a court decree or award of any tribunal or authority is not spared from the cloak of protection flowing from the previous sanction by the state. B. It is the non-tribal who has to apply to the collector for such previous sanction. The need for the non-tribal to apply brings in privity with the state the commitment and affirmation from the non-tribal to buying the land. C. A lease or mortgage of less than 5 years may be directly sanctioned by the collector. For any other transfer, the prior sanction of the state government is mandated before the collector may sanction the transfer. D. Even for according such sanction, the previous entails a preemptive right of first refusal in favor of any tribal residing in the same village or within a 5 kilometers radius, who may acquire the land superseding the non-tribals intent to acquire the land. E. For transfer of tribal land in scheduled areas, prior sanction of the local Gram Sabha would also be necessary. F. The only exception to the need for state sanction for purchase of land in scheduled areas by mutual consent is in cases where the land is required to implement vital government projects, where 2. The amount of compensation for purchase of such land has to be arrived at in a fair and transparent manner. G. Section 36A in bracket 2 enables the collector to provide sanction subject to such conditions and in such circumstances as may be prescribed. H. When the sanction period of lease or mortgage expires, regardless of any provision of law or court decree or tribunal's award or order, the collector has the power to restore possession, whether on the tribal's application or of the collector's own accord. Stop.